James, an Ohio resident, received a summons informing him he was being sued by LVNV Funding over a nearly $3,000 debt they claimed he owed from an old credit card, originally from Credit One Bank. He had never heard of LVNV and was confused because the account had been charged off over 4 years ago. The letter said Resurgent Capital was the servicer, but all communication was coming from an outside law firm. Step 1. James responds to the lawsuit. Instead of ignoring the court papers, James filed a written answer with the court, on time. He used a general denial, stating he lacked sufficient knowledge to admit or deny the alleged debt. He included a request for proof of ownership of the debt. Lesson: always respond to a lawsuit. Never ignore it, or the court will grant a default judgment. Step 2. Demanding debt validation. Separately, James sent a debt validation letter to Resurgent Capital under the Fair Debt Collection Practices Act, FDCPA, asking for the original creditor name, a copy of the signed agreement, a complete payment history, proof that LVNV owned the debt. Resurgent responded with a generic account summary, no contract, no proof of ownership. Step 3. Court hearing and motion to dismiss. At the hearing, LVNV's attorneys brought a bill of sale, heavily redacted, a final account statement from the original creditor, no signed agreement, no chain of title, and no witness. James pointed out to the judge that they could not prove the debt was his, they could not prove they owned it, and their evidence was inadmissible hearsay, no live witness to authenticate it. The judge agreed and dismissed the case with prejudice, meaning LVNV cannot sue again for the same debt. James walked away without paying a cent. LVNV could not prove ownership, the account details, or even that James agreed to the original terms.